Hello and welcome. We've got certified family law specialist Casey Marti-Corena, my partner, that's going to be helping us deal with the nuances of recordings in domestic situations where there's allegations of domestic violence. Stay tuned. How are you, Casey?
Hi, Dawn. Thank you for having me.
Thank you for coming. It's always great to have you on the program because you're so experienced and knowledgeable, and your analysis is always really, really profound. In this case, it's going to need you because it's on an important topic. It's about recording. Actually, I shouldn't just say recording. It's about recording without the consent of the other, right?
Right.
So could you explain, before we talk about the case, what is the general topic today?
So, the general topic, we're talking about recording someone without their knowledge. And in California, there has to be consent from both parties in order to record them. Otherwise, it's considered eavesdropping, it's illegal, and you can be criminally prosecuted. So, what we're talking about today is, well, how does that play into family law and certain exceptions in the law where people may be able to record the other person without their permission?
Okay, great. And we've got a fairly new decision just published in 2024. And what's the name of it?
So this is BRC versus BEC, and for confidentiality, they used initials only, but this case was just published April of 2024, so it's a brand new case, specifically on the topic of recordings.
Okay, alrighty. So why don't we set up the facts? I know it begins with a couple of kids, right?
So the basic outline is that we'll call them husband and wife. This is a divorce proceeding, and this is now well into the divorce proceeding. We have a set of twins, and throughout the divorce proceedings, wife files a request for a restraining order against husband for her protection and the protection of the twins. So that's essentially kind of the background of the case. And then moving forward, while the divorce is pending, wife files for a request for a restraining order. So that is how the case got into court. So getting deeper into the facts, wife claims that husband committed domestic violence by way of verbal abuse, lots of nasty names being called, berating her, yelling at her in front of the children, things of that nature, essentially dragging out arguments for hours and hours. So,
Wait, you missed one.
what's that, Don?
Throws hot soup in the sink.
Throws hot soup in the
Splashes on the
sink.
children.
Splashes
And
on the
throws
children.
a bag of cheese at mom.
Right. And there are a few other things, lots of name calling and names that I won't repeat.
Right.
But essentially, there's that type of behavior. What we don't have is we don't have a black eye, we don't have a punch in the face. So that's kind of one area where this case is interesting, and also for practitioners, something to cite to when you don't necessarily have a case with physical violence. We know that the law acknowledges coercive control, emotional abuse, disturbance of peace, but I think we know as practitioners those cases are really hard to prove. Even though the law says that indeed this is domestic violence, and sometimes you might outline a handful of examples of those types of things happening, I don't think that the courts have caught up to the research and the psychology of this. The courts have not quite caught up and deemed this, I think, domestic violence, or it's harder to prove, I should say.
Yeah, if you take away what we're going to learn about with the recording, you essentially have a he said, she said, right?
You have a he said, she
And,
said,
and that's
right?
very, very difficult to prove. And that type of behavior could have gone on for, 20 years or whatever length of a marriage without corroborating evidence. Very difficult to get a restraining order or get a factual finding for the purposes of custody or even spousal support.
Right, and it's just, it's so discretionary. It's who's your judge? How are they feeling that morning? Do they like you? Do they not like you? Do they believe you? Sometimes it's really difficult to showcase the dynamics of a family in, a 30-minute or 1 hour proceeding. And, how does this judge feel about it?
Yeah.
Maybe it's not enough. Maybe it's not enough for this particular judicial officer.
And I'm finding right now, I don't know if you've noticed this, but the courts are really, really examining this evidence closer. They're more thoughtful and, I guess, hesitant to issue restraining orders like they did before, because in our world, people are using domestic violence. Not everybody, but there are a lot of people are using it as a tool to get somewhere in the family court case, whether it's primary custody of the kids or spousal support. So we know that there's a lot of exaggeration that goes out there, and we also know that there's people that don't tell the truth a lot of times. So courts are more difficult to get these. It's harder to get a restraining order these days than it was in the past. So in this
Right.
case here, it was the type of evidence that could be difficult, but we've got a recording. So
Right. So moving into that phase of the case, so we're at the trial level, and wife produces 3 recordings. Okay. So what's on the recordings? Husband using the really nasty language, calling all the name calling. Husband driving and wife begging him to pull over, and husband refusing. Incidents of fighting and berating and yelling around the children. So there are various recordings. So at the trial level, husband objects, and under Family Code 2022, which is on eavesdropping and saying you can't use this evidence, and also objects, number 2, based on the penal code, saying that you need 2-party consent, you have to have consent, and it's illegal to record someone, period.
So he's saying, I didn't agree to this. I didn't give you my consent. She recorded me without gaining my consent, and it should be inadmissible, Your Honor. So you can't use this evidence at all.
Exactly. So that's what the objection was, and guess what? The judge agreed. So initially, the judge excluded the evidence. So then wife files essentially a motion for reconsideration and cites the exception to the penal code. The exception to the penal code says that there are exceptions in a case of obtaining information for purposes of a restraining order. So this is kind of where the analysis of the case starts. So after considering the exception to the penal code, the trial court allows the evidence in. Fast forward, the lower court grants a restraining order, and then husband appeals. So then now we get into husband's appeal and all of the legal arguments that took place there.
And I just have to say this was a Sacramento case, right?
Right.
And I love the confidence that some judges have where they're going to read the code and they're going to come up with a different conclusion that thousands and thousands of other judges haven't. They've to say, wait a minute, the code says that there's an exception here. And it has the courage to go ahead and apply what the judge thought was appropriate in this case.
Right. So this is kind of an interesting point because, it's black and white. There is an exception. It's an exception in the penal code. So speaking from my own practice experience, maybe a year and a half ago, before this case, I appeared in court on this issue. The judicial officer challenged me saying, well, it's a penal code. Where is the case law that says that this applies in family court? There is none. There is no case law, but where's the case law that says this does not apply in family court? At that time, what I was kind of relying on was a treatise in the ACFLS journal, the Family Law Specialist Journal, which analyzes this issue and concedes in a footnote that there was no published decision specifically stating that this exception to the penal code applies in family law. But if you just argue the policy of it, if you look at the legislative intent, why do we allow potential victims of domestic violence to gather information in the background? So this case goes into discussing some of those challenges, the public policy, and also kind of gets into one little nuance, which is husband's argument that, well, this exception doesn't apply because no restraining order had been filed. She has to file the restraining order, and then she's allowed to record me to gather evidence. So the court also analyzes that nuanced argument in the decision.
Yeah, going back to what you were saying about the penal code, applying, I believe that, a real study of domestic violence in California would show that the Domestic Violence Protective Act cuts across courts, the criminal court, family court, probably other courts, and stuff. And so, for that judge that you were in front of to say, where's the authority that you could use a penal code in a family court proceeding? It's like, we use all kinds of codes in family court. We're not just restricted to the family code. And again, the Sacramento judge took that bold step forward and said, hey, that applies over here.
Right, and what I did in that case was, if you, as you know, if the restraining order is granted, then the protected party is allowed to record the other side. That's an exception right there. The fact that the court forms and the family court allow an exception indicates that indeed this has already been, I guess, litigated by the legislature, right? They've already vetted this issue, and it's already determined that an exception is appropriate in some circumstances. So it kind of follows that someone would be able to use this exception in the penal code and family court as well.
Okay, so going back to the legal analysis here that you're about to launch into, there's a kind of a mental gymnastics that the Court of Appeal plays here, right? Because the wife obviously didn't pick up her phone and say, okay, I'm recording you. And she certainly didn't say at the time, or write it down somewhere, I'm recording you because I plan on getting a restraining order, right? And
Right.
she testified about what her intent was. So could you talk a little bit about that?
Okay, so then this is kind of like a two-part analysis that happens here. Is number one, is it required that a restraining order be filed first? And then number two, it goes into, well, it comes down to the entire case is going to turn on what the person's reason is for the recording. Okay, so for number one is a restraining order required beforehand? The case answers the question. The answer is no. The analysis was, you know what? Essentially, the husband was reading the code far too narrowly. The way that the husband was seeking to interpret the code didn't coincide with the spirit of the code in the first place.
Doesn't make sense.
Okay, so what is the spirit? I think we should touch upon that.
Sure.
The spirit is allowing people in he said, she said situations, right? And we know that domestic violence is the cause of a lot of deaths. Allowing that person to gather evidence, right? In a what typically happens in a private setting. So that's the spirit. Is the public has a concern about children and people that are victims of domestic violence and being able to gather evidence.
Right, and here if the court went with the husband's interpretation of the statute, hold on for a second. I'm going to go get a restraining order, and I'll come back and I'll record you, right? I mean,
Right. It just
and the court made fun of that.
It kind of made fun of it.
Yeah.
It just said, you're looking at it far too narrowly, and also if we look at the plain language of, did the full analysis when there was an ambiguity in the law. We look at the plain language. We look at the legislative intent. And bottom line, it did away with that argument. So, future litigants that make the argument, this case makes very clear that a restraining order need not be filed before you pick up and start recording. So then it goes into the second phase of analysis, which I think is super important for us as practitioners, and that is, well, essentially the entire case is going to turn on whether wife or any litigant picked up and started recording for the purpose of gathering evidence for a restraining order. So I think this is an area where I can anticipate the defense saying, "Oh, well, why was he or she recording in the first place?" Kind of attacking why the recording was happening. Sometimes, I always ask people, "How many recordings do you have?" I mean, are you recording over, dinner when you guys are talking about his promise to take you to Europe, or are you recording because you were scared and there was, those types of situations? So the court got into the analysis of what happened in this case, and we can use it in future cases. And essentially, wife said to husband, "Stop, or I'm going to report you." Okay, that's a clue right there. Hey, I'm planning to report you, so you better stop your behavior. That the court indicated that was evidence that indeed she was going to go in the direction of reporting or gathering a restraining order. The court also looked at the fact that the evidence was obtained, the recording was obtained, and she filed her request for a restraining order 3 weeks later. So in my mind, 3 weeks seems like a long time, but hey, this case is saying 3 weeks is indicative of someone. It tends to show that someone was going down that path
Sure.
of gathering evidence. So the third thing that the court looked at was, indeed, the allegations in the petition for restraining order and the name calling that wife mentioned and all the very specific names were indeed heard on the audio. So it tends to show that essentially that wife she had undergone abuse before, and she was recording in this instance to gather evidence of abuse. So the court looked at those things. The court specifically said that the evidence on why wife recorded husband was sparse. So I think this is an important point. This case is acknowledging that wife's evidence was sparse, but still found that it was enough. So if we are litigating this issue and the defense is like, oh, they don't have enough to show why they were recording, or if counsel on the other side is trying to undercut why someone was recording, I think this case says, well, this sparse evidence was enough. And I quoted those words. The sparse evidence was sufficient in this case. So
yeah, that's important, because I think what you're saying is the recording applies to even lighter cases of domestic violence, even if there's no physicality there, but it's like abusive, words and demeaning behavior.
Right.
The Court of Appeals is going to say, it doesn't matter. You can't use it wasn't really strong domestic violence, so you had no business recording me. I wasn't in danger of my life.
Right.
Right.
Well, I have one for you, Dawn. I think I mentioned this, but on another case after this April 2024 decision, when I indicated that there was an audio recording, the judicial officer, the initial reaction was, well, if it's an audio and not a video, how is that supposed to show domestic violence? So I was kind of like, okay. So my response in the moment was, well, the court can draw inferences. The court can look at the totality. The court can look at all of the evidence combined with the audio. So that was kind of an interesting point. But, and then we go into another area which we haven't addressed, and that is, this case is pretty clear that your audio should come in, right? Your audio should come in.
Right.
If it's taken, you have to lay the foundation with the witness. When did you take the audio? Why did you take it? For what purpose? Kind of lay the foundation, and it should get in. But then we have the other area, and that is impeachment evidence, right? So there's that aspect to it, and I think that was what I would rely on before this case was published, is if the judge denies it, at minimum it is impeachment evidence, and it's this evidence shows that Mr. So-and-so or Mrs. So-and-so testified very differently about these same incidents just yesterday.
Yeah.
So
I got a lot. This case, we could spend probably 2 hours talking about this, because we've got such a long history of dealing with domestic violence cases and issues regarding getting evidence in. One of the things that I really picked up was the fact that the wife never said during her testimony explicitly that I recorded this incident because I wanted to get a restraining order. What the court did was read the facts of the case and made inferences based on what she testified to. But I think that as a practitioner, and we're talking to people that are at risk of domestic violence, we want to make sure that they know what their rights are and that you can do this for the purpose of getting restraining orders. And then, of course, when you're examining somebody on direct examination, you want to ask that question: did you do it for this purpose?
You have to.
Yeah.
Because I think in this case, it specifically uses the word that the admissibility hinges on whether wife made the recordings for the purposes of providing evidence to the court on a DVRO.
So how can a situation apply where it captures domestic violence, but somebody was not recording it for the restraining order? And I think you hit on this before. You could be sitting at the dinner table and saying, hey, I want to go to Europe, and you've been promising me to take me to Europe for 3 years. What's going on here? Well, I'm going to record you one more time. This time, promise me you're going to take me to Europe. Well, I don't want to take you to Europe. And then all of a sudden a fight ensues, right? that might be a case where that recording was not for the purpose of getting a restraining order.
Well, I think that's different, and let me tell you why.
Okay.
Because you're pulling out the camera and you're saying, I'm going to record you. Just like if we call the customer service line and it says, this line is being
Oh,
recorded.
you're being technical. Okay,
Okay,
let's,
hold on.
let's assume there's a hidden camera. Okay.
Well, that's the point. This line is being recorded. Guess what? You can hang up.
Right.
So if you are having an argument with someone and
Implied consent.
you just say like, I'm going to record you, but you know what
Wait,
she
wait, wait,
did.
wait, counsel. Let's go back to this here. You got a hidden camera, okay? And the wife is like, and I want to talk to you about, this trip. Now, you've told me many, many times that you were taking me to Europe, and you never did so. Now, what's going on? And all of a sudden, he blows up, and he pounds and he starts throwing things around and stuff. Now, she didn't record that. Or how about one of these security cameras that are in the house, and she doesn't tell anybody, that it's there.
Okay.
And so there are instances where it could still apply, I would think.
So here's what I think. I think that the hidden camera, your only way out of that is to argue that it's not a confidential communication. Because in order for this to even apply, it has to be a confidential communication. So that's, I guess reasonable expectation of privacy. If you're having a conversation, at a restaurant, it's probably not a confidential communication.
Yeah.
Because, when I have a case going on with nuanced issues, I take poll and talk to, a lot of people. But one person made an interesting point, and the judicial officer in her case agreed, and that was, well, were the minor children present? So do you have an expectation of privacy if the children are in the room? And in fact, that argument worked in her case.
Wow.
So,
Okay.
I think that it hinges on, is it a confidential communication? I think if it's a hidden camera, 2 people in the home, I think that's a confidential communication. It's probably an illegal recording. If it's a camera in the home, people, for some reason, put cameras and just record the living room, the front door, and everything else. We all know there's a camera. I don't know I think a security camera is a different analysis because we all know there's a camera there versus or another example is, you're in the front of your building, and we all know there are security cameras outside of the building. So I think that's a different situation.
Okay. So another nuance, I guess, is you said that, if I raise the camera and I say, okay, Casey, what did you have for lunch today? And you start talking to me and telling me that you went to get pizza, that's implied consent because you haven't said, yeah, I consent to you recording, but you continue talking because I've got the camera pointing in your direction. A way out of that is I don't consent to you. Put down that phone, right? So people...
I think you need to walk away. That's what I think. I think if the phone is out, I can record you if I want to. I've seen this a million
You
times.
mean if I say, hey, I look right in the camera, I'm going, I don't consent to this. Put the phone down. And then I continue talking. You think that that's implied consent?
I think it's implied consent.
Because you keep talking?
I think that
Okay.
I think I can record you if I want to in a public place. And if
Well, I'm talking about in a private place.
if you don't like it, then you can leave. In a private place, I mean, I think I don't, it's not surreptitious. This whole law and all of this eavesdropping, it's all based on privacy. But if someone just says, I don't like it, don't do it. I mean, it's a different analysis if you take it and, put it on a TV show or something like that. But I think people can record you.
Okay.
And if you don't like it, you can leave the room.
Well, to me, the bottom line about this decision is this is earth-shaking. I mean, because we have been tiptoeing around recordings for domestic violence cases for many years now. There's been some cases where I've gotten them in, other times I haven't, and the courts have looked at various angles one way or the other, and we're always afraid that we're going to get criminally prosecuted, right? Because there's cases that we've recently studied where a lawyer got hit with like $70,000 for a recording, and stuff like that. So these things were always, and they probably still are, but they're very scary. Now we have kind of an opening, and it says,
So I would say, Don, this is not new law. It's not.
No.
It is not new law, but it makes it very clear that, yes, the exception to the penal code applies in family law. It outlines the public policy. It's just a go-to discussion. Also, I believe that family judges are intimidated by the penal code and eavesdropping and criminal prosecution, and they err on the side of, okay, I'm not going to admit that because it's scary. But I think this case makes very clear that, yes, you can admit it. yes, this applies in family law. I think it kind of makes judicial officers feel a little
Yeah,
bit
it's
safer.
it's a new interpretation of the law, and it's a decision that gives us confidence that we could bring in this type of evidence a lot more than we used to. And fortunately for victims out there, maybe this is going to be something that's going to protect a lot more people in what we do because somebody comes to you, Casey, and says, "Hey, he's been abusive to me or she's been abusive to me through the years." The first thing you're going to say is, "Where's your corroborating evidence?" You're always going to want to know that. You don't necessarily need it. I mean, the strength of your testimony could be enough, right? We know that. But typically, you're going to want to see either photographs, you're going to want a voice recording or something like that, right?
Right, absolutely. So, yeah, essentially, one of the other policy points in this case was that they want to allow people to gather their evidence without the fear or threat of criminal prosecution.
Thank
And
goodness.
right, absolutely. So, for all of that, we are thankful as practitioners that this is available to us. And it also tells us as a practice point that if we are representing the moving party, that we really need to, understand how and why the audio recording was taken in the first place. And if we're on the defense side, I would want to know more. I would want to know how many audios do you have? Have the audios been cut in any way and edited? I would want to have that information.
And it's all really became a big problem when these darn iPhones came out because everybody's got a roaming camera with them now and stuff. And it's kind of like unrealistic to think that we can govern people from recording each other and having these really bright line rules like that. So it's nice that this interpretation of the law is allowing it.
Right.
And thank you for breaking this down. This is really, really good.
You're welcome, Dawn. Thank you for having me.
Okay, and thank you for joining us, and we'll see you next time.